Ladies and gentlemen, boys and girls, hello, namaskar, and welcome to LawCharcha. We are in midst of understanding the life cycle of a criminal case. In part 1 of this series, we saw in what way the criminal law can be set in motion and the basic stages in a criminal proceedings that are commenced after registration of an FIR. Those who have not watched the earlier video, please find the link on top of your screen and also in the description of this video. I would request you to first watch the earlier episode of this series so that you are in sync with this series.
So let's recap what we have seen in the last video. Criminal law, how it is set in motion. There are four ways, and we are dealing with FIR and how a case proceeds on filing of an FIR. These are the basic stages. There is ample scope for further litigation in between these stages. And that is what we are going to see in this video, what possible litigation can take place between registration of FIR and filing of the chart sheet. As you can see, these are the possible litigations that can often take place between these two stages. Writ petitions before High Court as well as bail applications, either regular or anticipatory, that is the pre-arrest bail applications. I am only broadly placing these sub-litigation in these stages of the life cycle. There could be additional litigations also. Let's understand writ petition for quashing. This is filed by accused if, in his view, the FIR itself ex facie is false or it does not reflect his role in the crime, or in the statement of the first informant, his role is not reflected or there is no role attributed towards the petitioner. Such petitions are placed before a division bench of the High Court. The High Court, if it finds prima facie material in the petition and it feels that yes, there is actually no role attributed to the accused, then it can allow the writ petition. And pending that writ petition, it can pass certain interim orders. It could be staying the investigation, letting the investigation continue, but it may issue directions not to file charge sheet. It may also pass order protecting the petitioner accused from being arrested. That also can be done. And any other orders depending on circumstances of the case. Usually notice is issued to the state, that is the government, for taking instructions and replying to the petition. There are two sides to this. There could be actually a genuine FIR that is filed and the accused may be using this litigation, that is quashing litigation, as an option for delay, as a delaying tool, or rather I would put it this way, he could be using it as a delaying tool. On the other hand, the FIR may be indeed filed with an ulterior motive and on basis of false facts. These things do depend on the facts and circumstances of the case. But it also reflects the importance of contents of an FIR, especially the statement of first informant. Because ultimately, the statement of the first informant is what is analyzed at the hearing of the petition for quashing of an FIR. I must also mention here that at times an FIR is sought to be quashed mutually by the parties. In such cases, a petition is filed by the accused and the first informant has to make an affidavit stating reasons why he or she does not want to proceed with the case. In such scenario, the High Court may impose cost, and it does, for using the government machinery before allowing the petition. It depends on facts of each case. Supreme Court in case of Parbat Bhai Ahir has given certain guidelines in this regard. I will also place those guidelines on the screen at the end of this video. Apart from quashing of FIR, A transfer of investigation can be also sought. It could be sought for when the investigation itself is not being conducted, or it could be sought when investigation is being conducted dishonestly. There may be instances where some powerful politician or a business tycoon is pressurizing the police and thus it is influencing the investigation. In such scenario also, transfer of investigation can be sought, or any other like reasons. These writ petitions could be allowed or rejected. Because of the sub litigations in the case life cycle, as you can see depicted in this graph, there can be a delay in disposal of the case. Now, what happens if the petition is rejected and then it is challenged? These petitions, which are rejected, the judgment of these high courts can be challenged before Supreme Court by way of an special leave petition. Now, apart from the writ petitions, other litigations that can arise are with respect to bail and anticipatory bail. Though the difference is that these litigations do not usually stall or halt the investigation or the filing of the charge sheet. To understand concepts of arrest, bail, and anticipatory bail, please watch my videos on these specific subjects. So, in this video, we saw the two variants of litigations that can be filed between registration of FIR and filing of the charge sheet. In the next video, we will jump to the next stage, that is the stage between charge sheet and framing of charge. That would be in the next video. As I had promised, these are the guidelines passed by the Honorable Supreme Court with respect to quashing of an FIR. The writ petitions that deal with quashing of FIR. You may pause the video for reading or noting down these guidelines. So, thanks for watching this video. Do subscribe to this channel for watching many more such videos and sharing the knowledge on criminal law and various other laws. Thank you. Thanks for watching.